And we're on.
Well, hello everyone, and welcome to Practico's Costs podcast. This is our way of dealing with the COVID lockdown. Instead of the breakfast meeting, which so many would have been able to attend, we have decided to have effectively a chat between friends. So the podcast is going to consist of a chat between Ben Williams QC, well-known cost counsellor for New Square, Andy Ellis of Practico, and me as chair, Jeremy Morgan, a retired cost barrister. The format obviously will be slightly different to the breakfast meeting. There won't be any bacon sandwiches, but you'll also be spared the fire drill, which I've had to read out in the past. In terms of format, I was thinking something a bit like the lunch break in Test Match Special, but without the cakes and without the pigeons on the pitch. But let's go then straight into the first issue which we were going to talk about, which Ben will introduce.
Yes, thank you, Jeremy. We were going to start by talking about a detailed assessment, which doesn't sound very exciting, but this is a detailed assessment that got the most hits, I think, on the lawyer website for the particular day that it was reported. And that's because it allowed us a prurient insight into the world of brief fees and accountants' fees in first-class commercial court litigation. It's the detailed assessment of the massive commercial court trial in Deutsche Bank and Sebastian Holdings, where a cost order was ultimately made non-party against the then controller of Sebastian Holdings, who's a prominent Norwegian billionaire called Mr. Vick. And Mr. Vick, unsurprisingly, is challenging costs which amount to many tens of millions. And a particular feature of the costs are the fees of counsel and the fees of the accountants. And we'll begin by summarising the fees of the accountants is Deloitte's. Striking feature is this: though this was a commercial court case involving Freshfields that went through a very long trial, a trial of many weeks, nonetheless, the accountants' fees are still higher than the fees of Freshfields themselves. The total conduct of the proceedings, they're £24 million. And as the case was initially presented, you have page after page after page of Freshfield's fees very properly presented in a bill of costs. And then on towards the final page of the bill of costs, there is simply a one-liner, Deloitte, £24 million. So it does throw a certain absurdity into relief, where you have page after page after page of detail for solicitors, and then for in fact a greater sum of cost because it's a disbursement, you have a single line. Then as to the fees of counsel, it's an absolutely first-class counsel team. The fees, as you would expect, are substantial, but there was a particular challenge to the fees of the lead counsel, who's now a High Court judge. His brief fee for trial was £1.5 million, and then a succession of lower fees for the second still for 900,000, and two juniors in the lower hundreds of thousands. So as I say, it allows an insight into how the other half live.
Exactly.
I'd like to way you put yourself on the other.
Sorry, how did they? How did Master Gordon Saker approach that brief fee? Because I mean, I've only seen the, the sort of headlines, and I think the quote was something along the lines of, "It's not the job of the cost judge to, set what people should pay their barristers, but was ever thus." But it doesn't stop the knife being wielded on occasions when it occurs to a cost judge that they're unreasonably high in some respect.
Yes, of course, it's an atypical case because even by commercial court standards, as the judge himself said, it's at the top end. So no issue here of proportionality. As it happens, there wouldn't be anyway because it's an indemnity basis assessment. But I suspect this is one of those cases where the indemnity basis makes almost no difference because of proportionality simply not being a factor. The assessment of the brief fees is in fact you could almost call it a highly conservative one. The judge reiterates the principle that between the parties you can't claim the cost of preeminence. He doesn't suggest that is a principle that doesn't apply on indemnity basis assessment. He cites the well-known Simpson's motor auctions case from Mr. Justice Pennyquick and says that remains as authoritative today as it does 60 years ago. So he takes that as his starting point. As you just said, Andy, he reiterates that detailed assessment isn't about determining what is reasonable for barristers or solicitors to earn. It's just about determining what's a reasonable market rate having regard to the market. and that is in the same vein as a decision of the House of Lords, I think in the 1990s, in a criminal case where there was an attempt by the Lord Chancellor's Department to have a pop of what was charged by leading criminal silks with reference to what, say, NHS consultants got paid, and similar, and university professors and similar sort of people at the top of their respective professions, where the House of Lords said, well, that's simply not the job of their taxation. It's not, it's not for us to decide what barristers should earn. It's down to the cost judge to allow a reasonable market rate, and the market rate is the market rate. And of course, in the commercial court, that works. There is a market. It becomes very artificial, actually, in the less highfalutin worlds of sort of personal injury, or all those areas where everything's on a CFA, all those areas where there's still legal aid, where the reality is there isn't a true market, or if there is a market, it becomes a kind of circular and self-sustaining one. But here there is a market. And the other very conservative way the judge dealt with matters is he reiterates the brief fees are not about hourly rates, which is that he remarked in argument, though it doesn't come into his judgment, is something that even most clerks don't any longer seem to understand, because he gets clerks appearing in front of him adopting an entire hourly rate approach. But it's not just that, it's a charge for commitment. So one of the interesting things about the way he deals with the brief fee here, he doesn't just deal with the brief fee as covering the work up to trial. I mean, even though the work after trial, of course, is remunerated by refreshers. But in terms of determining the brief fee, he takes into account 6 months of preparation and a 3-month trial. So what is a brief fee for 9 months of work? So he is adopting the approach, which I have to say I respectfully would agree with. As a barrister myself, I would. That it is a charge for commitment. It's not just a charge for time. And because you don't start getting you don't keep getting refreshers as soon as the trial stops or the trial settles, there has to at least be some increment to take into account that you lose work not just in the run-up to trial, but after the date for trial to start if the case settles early. The other thing he does is which is perhaps more surprising, is he reaffirms traditional sort of rules of thumb. So the lead silk, his fee is taken as the index point. The second silk, it gets 2/3. And he says that for the juniors, it's again a useful rule of thumb that they should get half what the leaders get. And he basically allows them about half of what the second silk got. Well, when I say allows, he in fact allowed all the fees in full. So I mean, as I say, it may really be that the interest of the case for most is the prurience of knowing what goes on, at that level. Where, in fairness to the practitioners involved, it's a very rarefied world with people of very rare talents acting for very rich companies and people who are prepared to pay for the best.
I found the other aspect also very interesting, Ben, the treatment of Deloitte's fees, because Master Gordon Saker raises the question that solicitors' fees are subject to minute analysis, as you say, page after page of detail. And then you just get this effectively a one-liner for Deloitte's enormous fees, which seems to me to raise an interesting question nowadays when we do have, time recording, and basically everyone does record their time. So with computerization, we have the means of actually dealing with solicitors and accountants on a very similar basis, but we haven't yet gone down that road. And I suppose that raises the further question, is whether solicitors are subject to minute analysis, or accountants not nearly enough, or where we end up between those two extremes.
Yes, because what's interesting is, as we all know, even on indemnity basis assessment, where you are getting the benefit of the doubt, bills of cost for solicitors still tend to be reduced by a double-figure percentage, and not uncommonly by 20 or 30%, because the court's still finding an unreasonable amount of duplication, an unreasonable amount of churning, and also just the sense that people are doing an absolutely Rolls-Royce job where that simply isn't reasonable between the parties. And I suspect, although it doesn't often get articulated, a suspicion that at the very top end of the city, there is such a billing culture, particularly amongst the junior staff, that costs are distorted by the need for junior staff to meet their billing targets. Now, there is no reason at all, I suspect, to suppose that all those pressures are precisely the same within firms of accountants. And yet, how is the cost judge to make those sorts of adjustments to a firm of accountants' fees? Even though all experience with solicitors would tend to suggest that if the cost judge was given the transparency those fees might be reduced by 20 or 30%. Which when the fees are £10 million plus, and I said in this case 24 million, I mean that's potentially a reduction of £8 or £9 million. So it does throw into question, I think, the traditional approach to disbursements in circumstances where, as you said, Jeremy, there is a much greater ability to have transparency now, and obviously we are also in general seeing an increase in disbursements from third-party contractors because of things like needing to get third-party contractors involved in extracting information from IT systems and so on. That, you know, back in the day, you know, those were not things you needed to go to third parties to do. So there's an entire mitigation support industry which didn't used to exist.
Exactly. I mean, as a this is possibly an overgeneralization, but my impression was that the adoption of computerized time recording was probably earlier and more widespread in the accountancy profession than it was in the legal profession. Certainly for those accountants supporting litigation. I think the differences that I've always seen is the lack of granularity now in accountants charging. They're likely to be charging in much bigger blocks than solicitors are. You know, they certainly wouldn't descend to 6-minute units as a rule. I'm not saying nobody does, but you know, they wouldn't go down that far. And that the difficulty, if you're challenging, or you know, if you're challenging a big firm, it's you could add a huge layer of expense, I suppose, by trying to get expert evidence as to what accountants' fees ought to be, which again is probably a bit of an expensive exercise, and I'm not sure one that the court would really be that assisted by. So I tend to find the way in is more to do with if one is challenging fees, you know, the extent of the overlap between the work that they do and the law firm. And as you would with a section of cost, you could go down the route and say, well, look, you did a load of work there but didn't use it, or you did a load of work there that didn't, you know, that you probably went down a bit of a cul-de-sac that we shouldn't have to pay for. And that, rather than saying, well, look, you know, this is Price Waterhouse or Deloitte's, and you know, in my view, who am I? You know, they should be charging extra rather than why. What do I know? You know, and I'll say that as somebody who's struggled with looking at very lumpy forensic accountants' fees for many years from time to time.
Should we then move on to another very interesting practical issue in group litigation, which is the question of the choice of lead solicitor. There's a case not so long ago about that.
Yes, there was an interesting case. Again, it's one of those cases that throws some light on the sort of engine room of litigation, which we don't often see, because it was all about, you know, assembling groups of people into group litigation and arranging for them to be represented by solicitors and counsel. And it throws up some practical problems. The aspects of the judgment is a case called Lungau and Vendata, which is about a copper mine in southern Africa. It's a toxic torts claim. It throws up some interesting issues, as I say, some of which I think the judge does with very persuasively, some of which he perhaps skirts over. The particular issue is, as I understand it, is this: there's two groups of claimants bringing claims suggesting that their environment has been blighted by emissions from the mine. They're in different geographical locations. The first group was recruited by the day, and they decided not to recruit people from another geographical location because they thought they were further from the mine and their cases were weaker. But then Hausfeld comes along and it recruits people from that other community. They both want to have a group action, but Lido don't want to represent the Hausfeld cohort. And Hausfeld will also appear to want to instruct their own team of counsel. And so they propose that there should in fact be two subgroups within the GLO. And that has a very, very violent reaction, I can almost call it that, from Mr. Justice Fraser sitting in the TCC. Some of the violence is completely understandable on classic CPR principles. It seems to be disproportionate and wasteful to have two different groups going along, potentially two separate trials, everything looks like it gets duplicated. That's obviously unhelpful in terms of court resources. It's also potentially oppressive to the defendants. And as I say, his reaction to the proposition is quite violent. He calls what's proposed a Frankenstein's monster, which I suspect was rather harsh. But what he doesn't deal with is really some of the practical difficulties of what do you have where you have two groups, both being funded by no-win, no-fee agreements, where he is suggesting that the second group must essentially be merged with the first and therefore be represented by the lead solicitor, lead A. He emphasises that only one team of counsel is acceptable, so the lead solicitor's team of counsel. In circumstances where lead A and that team of counsel had rejected acting for those claimants because they didn't think that they were very likely to win or as likely to win. Now that does, that does throw some quite serious questions in a no-win, no-fee context. If we just assume these groups were the same size, and as we all know in group litigation, there's several liability for costs. So if you're admitting into the group who are paying for work done by the lead solicitor, another group that's as large again, suddenly, so that instead of being shared between 100 people, the costs are being shared between 200 people. Well, if of those 200 people, the lead solicitor expects 50% of them not to win, I'm not saying that is this case, I'm just using it as an example, then the lead solicitor is essentially being forced to work at half price. Because if they, at the end of the case, they're not expecting to recover the 50% share of the cost attributable to those members of the group who are expected to lose. And obviously you get the same issue with counsel acting on CFAs as well. Now I know, because I've seen the skeleton arguments, that these points were made to Mr. Justice Fraser, but in his zeal for emphasising, as I say, understandably, the sort of efficiency and proportionality advantages of combining the groups, he completely fails to address what seem to me to be some fairly serious issues about how you can essentially require lawyers to act no-win, no-fee for clients who they don't want to represent because they're not satisfied as to their prospects of success.
Is there a way around that in devising a GLO with generic issues which are perhaps more fairly spread across, or would cover both groups, and then leave the risk to individual costs in the cases which might be weaker? Would that be a way around it? I suppose it will depend very much on the facts of each case.
I think that's probably right. I think there's probably not a one-size-fits-all, a one-size-fits-all outcome. It's probably possible to deal with it by tailoring the cost orders at the end of the case and tailoring the cost-sharing order. Because of course you don't have to have an outcome whereby costs are shared between each person severally on an equal share. And equally, I suppose at the end of the case, the court could say, well, even though only half the claimants have won, nevertheless, they have still, the group as a whole has established that this plant was polluting. So we will award them 100% of their common costs, even though 50% of the individual claims have failed. But it's obviously a pretty discomforting experience for lawyers to have to wait to the end of the case to discover whether a judge is willing to show pragmatism of that kind. In general, as a lawyer, you deal with that when you're working no-win, no-fee by only acting for people who you think have got whatever your cut-off point is, whether it's 50%, 60%, 70% prospects of success. Obviously, it varies from lawyer to lawyer, the risk they're willing to take on. But to say you can actually be driven to act for people who you're not expecting to win, it does seem to be quite an outlandish thing.
I suppose it reflects the move from the bar to the bench of the judges, who now fail to see things as much as they used to from the point of view of lawyers undertaking the risk, and see things much more in terms of CPR style case management.
Yes, as we all know, cost issues are somewhat the ugly sister. I'm not if that's not a politically incorrect thing to say nowadays, I'm obviously referring to Cinderella. I think you're absolutely right about that. And in a sense, it is unfortunate that one needs to worry about these things. And in the old world where legal aid was available for group actions, and legal aid rates were rates that solicitors could actually live on, then obviously they got paid a reasonable amount, win or lose, and these issues didn't happen. But when you have had to convert root and branch to no win, no fee, then requiring a lead solicitor in a group action to act for a subgroup of claimants that they're not expecting to be successful, or at least don't meet whatever merit criteria they have set for their own clients, then it does give rise to difficult issues.
I mean, it would be hard to imagine any court forcing a third-party litigation funder to fund a subgroup of claims that it didn't satisfy its merits test on advice.
Yes, absolutely.
So why should it be any different for lawyers?
Yeah. I mean, the judge just seems to say, well, you know, they're just the lead solicitors. All they, all the lead solicitors do is they instruct counsel and they act as the liaison point. But it seems to me that in itself is obviously wrong. The lead solicitors are going to be taking the lead on the common issues. They are going to be, so all the work that leads up to the trial of lead cases, for example, is overwhelmingly going to be done by the lead solicitors. If liability for those costs is shared between a group into which the court has forced the lead solicitors to accept a large number of claimants admitted who the lead solicitors don't think will win, then they expose the lead solicitors to losing, the pro rata share of the common costs which are attributable to those members of the group. And
Yes.
as I say, these are things which Mr. Justice Racer doesn't even address.
No, and also, I mean, I don't know. I mean, necessarily we're generalising here, but I find that judges at the end of cases are less prepared than I would have expected to make broad brush cost orders where they should realise, or if they don't, should realise that a messy issues-based type order would create huge problems on detailed assessment. Nevertheless, they find it hard to get away from a type of partial cost order that reflects the judgment in a fairly sort of forensic way, dumping a massive problem and huge costs onto the assessment exercise later.
Yes. Yeah, well, I don't disagree with that. I think there is just, I'm afraid I do just get the sense that there is just some members of the judiciaries do just find these issues almost to be sort of a bit beneath the salt, if I can use that old-fashioned expression, or to use a different expression, just to be rather grubby. But lawyers haven't asked for these grubby arrangements. So, in fairness, for example, to Lead A, I could imagine there is a firm in the country that would have had more of a legally aided ethos. Working no win, no fee was something that has been imposed on them.
Yes.
And in those circumstances, the courts can't just turn a sort of haughtily blind eye, to arrangements which they may find sort of unpleasing. That's just not viable with the funding system that we've been given. Yeah,
no, well said.
Another handy weapon for defendants in facing claims like that.
Right.
Another issue which we've had a chat about was refusal of mediation. It's sort of runs and runs, this one, but anything of interest recently on that?
Yes, well, of course, on the assumption that people who are listening to us have some interest in cost issues, they've probably at least heard of Halsey and Milton Keynes, which was a decision of the Court of Appeal. I can't remember if it's 2003 or 2004. And it was followed by another case called PGF2 and OMFS in about 2013, which is a Lord Justice Briggs case. And those are both cases which emphasised the importance of mediation. And in the second case, the PGF case, it was said that even declining an offer to mediate, declining an offer to mediate, or simply being non-responsive to it, could lead to a cost sanction. And since then, there's been a steady dribble of cases where parties who've been otherwise successful have been penalised for not mediating, as most people will know. You do get the uneasy sort of sense that it's sometimes used as a bit of a crutch by judges to avoid making a cost order against the party they may feel rather sorry for, rather than an area where you can necessarily isolate clear principles. But there's been a recent case, and I don't think anybody would suggest it enlarges the law, but it's just an interesting illustration of how these things work. It's a case called Wells and CBRE in Aviva. And it's a case which raises a number of sort of classic post-judgment cost issues, issues-based costs, should there be an indemnity basis order, and so on. But the key issue, and it's the one that's got a bit of attention in the legal press, is it's another case where a party that was penalised for not mediating. And essentially, CBRE declined to mediate twice. Once it really just ignored matters, it was unhelpful generally, a bit obstructive in response to the letter of claim and such like. And then later in the case, in the run-up to trial, it declined to mediate again, saying there was no longer time. And the judge criticised it for both. Mr. Wells went to court and lost, but the judge said, well, it's just the sort of case where mediation might have unlocked things. It is perfectly clear. I can't claim to be familiar with the substantive issues in any depth, but it's perfectly clear it's one of those cases where there was quite a lot of development on all sides as to what the issues were perceived to be and how they were put, and concessions that had been made were withdrawn and so on. And the judge made the point, well, if there'd been a mediation at an early stage, those are the sort of things that would have come out earlier and more inexpensively. And it was also one of those cases where, although Mr. Wells ultimately failed because he didn't have the legal rights, one does get the sense the judge thought, yeah, but there was a pre-existing relationship between all parties of a commercial nature, and it's quite possible that a mediator might have been able to unlock an outcome which, although not strictly reflective of their actual legal rights and responsibilities, may very well have led to a sort of commercial settlement based on a sense of whether there was a legitimate grievance and some kind of moral obligation. And so, taking all those things into account, for the first period where CBRE refused to mediate, the judge deprived them of 50% of their costs, and for the period closer to trial, he deprived them of 20% of their costs. So it's an entirely fact-sensitive case, but it's another, it's another a sort of revelation or reminder as to, refuse mediation at your peril.
I quite like the idea that because of the pre-existing relationship, there might have been something a mediator could have done, which of course is very much familiar territory to people who do mediations. But interesting to see that brought across to litigation where it's not all or nothing, but it's one's legal rights or nothing.
Yeah, I think that's absolutely right, and I think it probably is fair to say that we as lawyers can easily forget that in most commercial disputes, you've got people who do have pre-existing relationships. Sometimes they've come to hate each other, but often they haven't. There's been some business setback. Everybody's trying to protect their own position. But that is the sort of classic thing, and this goes back to what Lord Justice Brooke said back in the original Halsey case. This is the sort of thing that skilled mediators can unlock, and they can come to outcomes that judges can't, because judges are constrained by legal tramlines. Whereas mediators can remind people, come on, you guys did business together, for some years, maybe you should be giving this guy a bit of a break, and people can, that way they can sort of feel vindicated by assessment, even if it isn't all that they might have achieved legally or hoped to achieve legally. So, I think this is one of those areas where it all seems to make quite a lot of practical sense. So, though, as a lawyer, it does lead you sort of uneasy about, first of all, the sort of randomness it introduces into the system and the unpredictability. And secondly, as I think we all know now, the extent to which demands for mediation and so on may be made tactically.
Yeah. Yes. I mean, certainly it's used, I think, as quite a blunt instrument by people, I think, more on the receiving party side, I think, in terms of putting added cost pressure, because from a paying party perspective, if one is ever involved with putting together budgets or projections of cost benefit analysis of running cases to detailed assessment, then there's a worst case scenario that one would paint, and then there's a really, really, really worst case scenario, which is that you go through a failed mediation and then go through a detailed assessment.
Yeah.
And that that is something that could even be a legitimate disincentive to go to mediation.
And I think it might be reasonable to say that the sort of thing we've just been discussing about, these sort of slightly imprecise but nevertheless very human issues that you may get in a commercial dispute where there are business relationships and something has gone wrong, and it might be possible to put the pieces together again at a human level, and that unlocks settlement. I mean, that all sounds a bit, much less plausible in the context of a cost dispute where you've had the substantive dispute, it's been decided, someone has presented a bill of costs. The other side can look at the bill of costs and say, well, here's where I think the duplication is. I think these hourly rates are high. This is what I'm prepared to offer you. I mean, there's if I can put it this way, there seems to be, rather less material on which a mediator might work some magic in those contexts. And no, I'm not saying mediation has no place in the cost context. There may be cases where it's very helpful, but I think it doesn't seem to have the same sort of reach that is described in cases like Halsey, where you can unlock intractable problems, because reality is in cost is not an intractable problem. If someone is demanding X, you're willing to pay Y, and you don't necessarily need a neutral third party to unlock it. There of course will be cases where people have got so entrenched or so unable to see the wood from the trees that would be helpful. But I don't think it necessarily ought to be something that is expected as a matter of course, because as you say, Andy, it does actually just potentially add an additional stratum of costs to what's already a fairly expensive process that most people think should be made cheaper, not dearer.
I mean, I think I think that's a really interesting sort of discussion about ADR and mediation, and I mean, I tend to quite like cost mediation where the bill is big enough, and that's one of the things that I'm really interested in. I'll be interested to see how the Deutsche Bank case pans out, because there was a huge discussion about how much detail you should realistically be expected to go into when you're preparing a bill that size, and how much information does the other side need to make cogent submissions and informed decisions, so on and so forth. But most of the time we know that multi-million-pound detailed assessments are really cumbersome. And in those situations, I put a big tick in the box, in terms of an assessment about whether mediation is a good idea. The other is that as you before, where there is some animosity between the sides, the fact that mediation tends to have you in your separate rooms for large parts of the proceedings and not together, like you're crammed together in a courtroom, or used to be, or even together in a sort of joint settlement meeting, is rather a good thing. But I mean, how have you found mediation during lockdown? Have you been involved in any?
I haven't done a mediation during lockdown. No, I've done quite a few video hearings, but not mediation.
Because I mean, I was concerned. I think we discussed this before, that one of the ways that mediation works is the sort of what I call the sort of waterboarding effect of all being locked up in the same offices, and until in the end, at some god awful hour of the night, everybody can't stand it enough, and they do finally come to a conclusion. If you're in a slightly more relaxed environment where you can ping in and out of an online mediation in a forum like this, with some separate rooms or WhatsApp groups going on in the background, there could be a tendency to drift.
Yes, that's probably right. I mean, obviously, one of the ways I think mediation does work also is it often gets the decision makers into close proximity, whereas in a cost context, if you have a detailed assessment, very often the decision makers are fairly insulated from it, and there's a couple of specialist cost advocates are grinding away in front of a cost judge, in the more or less privacy of the senior court's cost office for day after day after day. So from that point of view, mediation can be an unlocking process by getting the senior stakeholders, it gets their attention. It's a half day rather than 2 weeks. Points like that. So I mean, it certainly has a role, and I certainly agree with what you said about big cases. I think their detailed assessment really does become so difficult. I suspect that, however, for sort of day in, day out cases where party presents claim X and paying party offers amount Y, really a mediator wouldn't have much to say there.
Yeah, no, that's fine, very good.
Thank you. Of this segues quite nicely into an issue which Ben was reluctant to discuss, which is 4 New Square's cost ADR scheme. I think it'd be really interesting to discuss it, simply because it's quite an interesting idea. So Ben can be forgiven. He's not trying to plug the scheme, but to tell us something quite interesting about an innovative scheme.
Yes, I mean, this was obviously motivated by the C-19 lockdown, where we thought that there might be an appetite, for people, detailed assessments, particularly outside the High Court, are just not going to be given a high priority. And as the courts gradually reopen and try to catch up their backlog, one assumes, for a considerable time, that's likely to remain. So we started looking possibly at the idea of having some ADR process which we could help with at 4 New Square. And our first thought was actually the smaller cases, for the reasons I've just been given about the lockdown and the county court. But then, obviously, you start thinking about it and you suddenly realise, really for the reasons that Andy has given, ADR is perhaps, if anything, even more attractive in the big cases. What we're essentially doing is offering, to assist and in a flexible way. I mean, most of us have got mediation experience and we can mediate. But we're also, willing, for example, to carry out neutral evaluations. If both parties are, say, at loggerheads as to what an hourly rate should be, or to whether costs are proportionate. Rather than and quite often, once you unlock a big point like that, then the assessment follows. So rather than going through all the way through detailed assessment or to get a judicial decision on that point, you can just, without needing to commence detailed assessment at all, come to one of us and ask either for a neutral evaluation or for a binding expert determination. So those are the sorts of things we're doing. We're also willing to conduct paper assessments in the way that the county court conducts provisional assessments in bills of up to 75,000, but we're willing to do that for bills of a larger amount. That's the that's the sort of services which we're looking to offer. And it does seem to me that I don't think that you would necessarily get a lower quality of decision making from experienced counsel with a cost specialty, whether at 4 New Square or any other chambers that offer the service, than you would by going to the cost office or to a regional cost judge, and you potentially get a decision more quickly and through a less cumbersome process.
Have you had an experience? I don't know when it started. Have you had much experience of it yet, or is it still early days?
It's still relatively early days. We've had a lot of interest, and interest. I think probably in what I might call the mass market. Of course, this is one of those things which can only work if both sides agree to it. And in the mass market, you often have such entrenched differences between the claimant side and the defendant side. I've always been sort of rather unsure as to the extent to which you would get claimants and defendants both agreeing to use this novel procedure rather than going through the tried and tested one. And to, I suppose, to this extent, also you might also be said that we're more unpredictable because most people will know what their local district judge is allowing, and they won't necessarily know what we might do. But we've had quite a lot of interest, at the more bespoke end of the market from city firms and such like.
Mm. Well, good luck with that. The other issue which I was interested to see was raising its not ugly head a bit was solicitor and client assessments. I always loved solicitor and client assessments because so much of the basic law was decided by chancery judges in the 19th century at a time when chancery judges did not look down on costs as something infra dig. They were extraordinarily knowledgeable. But I gather there's a bit of a resurgence in that area, which may or may not be for good reason.
Yes, I think some people will remember Jonathan Swift's little ditty, "Fleas of smaller fleas that bite them, and so it goes ad infinitum." And what we have, and what we actually now seem to be seeing, if anyone listening to this is a personal injury lawyer, will forgive me, is we have we have the question of who chases the ambulance chasers, because there now seems to be a small industry of solicitors who are going around finding former clients of mostly personal injury solicitors, conducting mass market fast track work, who are saying, well, hang on a second, did you lose 25% of damages to these people? To which the answer is very often yes. And then they ask questions like, well, actually, did they check that you had legal expenses insurance? You didn't have legal expenses insurance, and often the answer seems to be that if there was a check, it can't have been a very good one because they're almost immediately found they did have legal expenses insurance. Or they're asked the question, and tell me, can we see your CFA? Because we wonder if that 25% deduction resulted from a 100% success fee. More often than not, the CFA is produced and it does. But you were a passenger in a car. You had literally 100% chance of winning your claim unless you were a fraudster, say the sub-ambulance chasers. And suddenly, a solicitor client assessment, which, if not a hen's tooth, was a pretty rare event, particularly outside the cost office, suddenly you're beginning to see hundreds and hundreds of these coming forward in the county court. And from what I have seen, it is something which is tending to increase rather than to decrease, because I think you are now beginning to get claims management firms which are themselves targeting the former clients of large personal injury firms. So there is a real resurgence. And although it's happening at the moment mostly in the context of small personal injury cases, I don't necessarily think it's going to be confined to those cases. And certainly solicitors who act on CFAs, whether it be for personal injury claimants or other claimants, may begin to see their success fees challenged, not as was traditional before the LASPO reforms by the opposing party, but by their former clients.
Mm. And will this in some cases be to the point where nothing is due? I mean, for example, failure to assess LEI properly.
Well, that's not an uninteresting point, because of course in a lot of these cases, in fairness to solicitors, the real motivation for not looking very closely at LEI isn't because they want to mulct their clients with a success fee. It's just if you go to LEI, the LEI will send it off to their panel firm, and without wanting to overgeneralize, very often the panel firms, they're not being very well paid for the work that they do. You don't always get the best job. Or at least that's what a non-panel firm would tell you. But that does enable the aggressor in these disputes to say, well, if you had done the LEI work properly, the case would have gone off to a different solicitor and you'd have been paid nothing. Now, I rather suspect, however, that the cost judges aren't going to allow that one. I mean, the other solicitor would still have charged them something. But what I suspect the other solicitor would have done in most LEI cases is they would have taken the costs that were recoverable from the other side, and that is all they would have taken. And so insofar as there have been deductions from clients' damages to top up the cost that's being recovered between the parties, they may have to be paid back.
Mm. And interesting also sort of overlap between solicitor and client assessment as a procedure and a negligence action.
Well, I mean, that's an interesting one, because I mean, to my mind, I think it's so far mostly just been assumed that, for example, a failure to elicit BTE is a point for detailed assessment. But I mean, on the face of it, I'm not sure that's quite right. Detailed assessment is about whether or not the success fee was, say the success fee was reasonably incurred. Well, on the face of it, it was reasonably incurred because the client entered into a CFA. You're asking the antecedent question as to whether should the client have been given different funding advice, and that certainly is something that is potentially a professional negligence question.
Mm. Isn't it up? There's something in my head from Massey and Carey going back to 19th century decisions about you've got to separate negligence from overcharging.
Yes, and these are, I mean, that case rings a bell with me. It's not at the tip of my fingers, but these are obviously important practical questions for two reasons. I mean, firstly, a professional negligence action, the solicitor gets all the protections of disclosure, oral evidence and a trial. And if you are, alleging, essentially misconduct against solicitors, aren't they entitled to those things? And the second point, of course, is may be very important for solicitors' insurance, because if they pay damages, professional negligence, subject to their deductible, they're insured. Whereas if a cost judge just says, because you didn't give the advice you should have given, you have to disgorge, some thousands of pounds of charges, that's something against which they're almost certainly not insured.
Hmm. Hmm. I think that probably about wraps it up. It's been, for me, fascinating to catch up with you guys, and the process is different, and that's been interesting. Whether next time we meet, it'll be with bacon sarnies and fire drills remains to be seen.
Bring your own bacon sarnie. Be the way to do it. But
I think it remains just to thank you both, particularly Ben, for participating and giving us some really interesting thoughts on not so new developments and new developments at the same time. So thanks very much.
Thank you. I should stop recording now.
Thank you.
Okay.